All right.
Good morning.
Alito has... Hi?
CASA came out?
Yeah, CASA came out. They seem to have limited the nationwide injunction to the parties before the individual district court judges. Yeah, they granted the Trump administration's request to limit it. Sounds like this is going to shift to class actions now. We haven't gotten a new decision yet, guys. I'm doing two things at once, but you guys got some of the analysis as well. But let's talk about the opinion. The court says universal injunctions likely exceed the equitable authority that Congress has granted federal courts. Significant that this is Justice Amy Coney Barrett, by the way. A number of us thought that this would come from the chief. So remarkable that this was given to her. From the opinion of the court, the principal dissent's analysis of the executive order is premature because the birthright citizen issue is not before us. Sotomayor dissents, joined by Kagan and Jackson. Jackson also has a separate dissent. At the end, the court says that the government's application to partially stay the district court's preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief with respect to each plaintiff withstanding to sue. The court instructs the district courts to move expeditiously to ensure that with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with the principles of equity. The court says that it is not deciding whether the executive order is constitutional. Yeah, they're not weighing in on birthright citizenship. Federal courts do not exercise general oversight of the executive branch. They resolve cases. Stop asking me to join the live. Turn off. Okay, turn off.
Well, we have reporters that are going to...
Barrett's still reading from her opinion. Alito says that next that the ruling will have very little value if district courts award relief to broadly defined classes without following the procedural protections for class certification. So this is going to pivot, as we were talking about before the live, an alternative to universal injunctions, because you still have the problem of if a president, not necessarily President Trump, but any president, acts blatantly unconstitutionally, which one federal judge has called this birthright citizenship executive order blatantly unconstitutional. But even putting aside Trump, any president, if a president comes in and takes all of your guns, right, that was one of the hypotheticals used during oral arguments, what can be done to stop that from happening because it's blatantly unconstitutional? And so the answer before now was universal injunctions, but now they're pivoting, it appears, to class action certification, quickly certifying all the relevant plaintiffs who would be affected by the decision. It sounds like Barrett is wrapping up her decision. This is interesting, and it's just the first opinion from Justice Barrett. So we still have 5 more that are coming. As David's pointing out in the chat, Justice Barrett's a former civil procedure professor. So this makes sense. Tough line for Justice Jackson's dissent by Justice Barrett. We observe only this. Justice Jackson decrees an imperial executive while embracing an imperial judiciary. Sotomayor is now reading from her dissent. I swear to God, they're doing lawn work behind us. This was happening yesterday. Guys who are just joining, we just got Trump v. CASA, the birthright citizenship case. We call it birthright citizenship case. But here the Supreme Court has granted the Trump administration's request to limit 3 separate district court judges' orders that were blocking them from implementing their executive order nationwide to the plaintiffs before them in each case. And there are organizational plaintiffs, there are individual plaintiffs who are pregnant and who are in the country illegally, and then there are state plaintiffs. So the judges are going to have to figure out who this applies to. But they essentially gets rid of the practice of universal injunctions. I'm just going to Google for class certification and see how often. Justice Alito says, I join the opinion of the court, but write separately to note. Are you serious? but writes separately to note two related issues that are left unresolved and potentially threaten the practical significance of today's decision: the availability of third-party standing and class certification. Can you guys hear me over the... Like, do you have to do that right now? This really... Like, literally just as the media is doing this. Okay, I'm going to talk loudly, but I can't stop them, so... let me see if Amy's going back in. So reading her dissent from the bench, Sotomayor obviously indicating strong feelings about this. Kavanaugh's concurring opinion notes that district courts do not have the last word on preliminary injunction requests. Courts of appeals and the Supreme Court can also weigh in, and that order of operation will not change. Yeah, it's 10:15 and we're still at just the first opinion. Maybe they'll be done behind us by the time we get the second opinion. They're going to be coming closer to me, so it's going to get louder. This is really unbelievable. I can't believe they're doing this right now. Are they doing that? Maybe they're doing this on purpose. Sotomayor contends that the Trump administration did not ask the court to completely block the lower court orders because it would have to show that the order is probably constitutional, which it can't do, she says. The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet shamefully, this court plays along. This is from Sotomayor's dissent. We're getting opinions right now. All the media is going live. Thank you. Okay. A little bit better. Thank God. All of these people. All of these people.
Well, we can't.
Whatever you need to do, but like all of these people, all of us, we're all on TV.
Broadcasting live, right?
Thank you so much.
Thank you.
It's only for a little while longer. Okay. So in the Sotomayor dissent, we're getting the merits preview on the underlying birthright citizenship issue, David's saying in the chat. Some of us were expecting. But again, this is not about birthright citizenship per se. All right, let's see. Oh, they stopped. Gosh. Blissful quiet. All right. Guys who are just joining, we have 6 opinions we're getting today. We just got the first one in the birthright citizenship case where the Supreme Court, in an opinion delivered by Justice Amy Coney Barrett, split 6-3 along ideological lines, granted the Trump administration's request to limit nationwide injunctions that were blocking them from implementing their birthright citizenship executive order nationwide. What exactly that means is going to go back down to the district courts, because the district courts have to clarify and make sure that their orders apply to every plaintiff. And there are different types of plaintiffs in all 3 cases. There are organizational plaintiffs, there are individual plaintiffs, like, for example, women who are here in the country illegally but pregnant, and there are state plaintiffs. So, again, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunction entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. Sotomayor omits respectfully from her dissent, as they're saying in the live chat. She's done that a few more times lately. And she should be wrapping up shortly, so we should be getting the next one soon. But now it's anyone's guess who's writing, what Roberts is writing. Since we kicked it off with Birthright. I'm just going to go briefly to, let's see, the document itself is 119 pages. There are concurrences. So from the top of Sotomayor's dissent, children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. She's getting into the merits. Again, the issue with birthright citizenship, the Trump administration interprets birthright citizenship differently than has been understood predominantly for the country since the 14th Amendment was ratified in 1868 after the Civil War. And the language in the 14th Amendment is all persons. Do you have a question for me? I'm getting a little wet, but it is what it is. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Since the ratification of the 14th Amendment, that has applied to any person born on U.S. soil, except for like a small group of people, and like diplomats who are here with embassies and things like that. But the Trump administration's interpretation is that subject to the jurisdiction thereof means some sort of political loyalty to the United States and does not mean just anyone who is born here. I'm just checking. I'm just pointing out what Amy's talking about in the chat. At Barrett's opinion for the court and the majority, she writes that prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give the plaintiff complete relief. Her child will not be denied citizenship. Extending the injunction to cover all similarly situated individuals would not render her relief any more complete. They're still reading from the opinion. We still have 5 more to go, and we're only 20 minutes in. So anyway, Justice Sotomayor is really talking about the merits of birthright citizenship off the top of her dissent. No right is safe in the new legal regime the court creates. This was kind of her point during oral arguments about what if a president came in and decided they wanted to take everyone's guns. You would have to go to a court, get them to certify a class action of relevant plaintiffs, I guess, of all gun owners. Okay. Okay. Anyway, the majority ignores entirely whether the president's executive order is constitutional, instead focusing only on the question of whether federal courts have equitable authority to issue universal injunctions. That's from the dissent. Sotomayor is still reading from her summary of the dissent, so we're still going on the first one, guys. A quick recap. Yes, for those who are just joining, we have 1 decision. We still have 5 more that we're waiting on. The first decision, the Supreme Court granted the Trump administration's request in the birthright citizenship / universal injunction case. And that basically limits their order to apply only to the plaintiffs before them. Now, they're going to have to go back down and figure out who exactly that applies to. But this basically gets rid of universal injunctions. And universal injunctions are when a district court judge, which is at the lowest rung of federal courts in our system, we have district court, court of appeals, and Supreme Court. When a district court judge has blocked the president from implementing his executive order or implementing a policy or something nationwide. And the Supreme Court is saying that likely exceeds the authority that Congress has granted the courts saying they're overstepping what the Constitution and what Congress has granted them and their ability to block the president from doing something nationwide. Courts have jurisdiction. You have to have things in order to get into a courtroom, right? You have to show standing. You have to show that you are harmed or will imminently be harmed. And so kind of putting all of those pieces together, a district court judge doesn't have the authority to block the president from implementing something likely beyond the parties before him or her, or the physical jurisdiction. It sounds like they're talking about the parties before him or her, the plaintiffs in the case. 23 minutes, as someone is pointing out, and we're still just on the first opinion. Will they use this to deny abortion national rulings? So that was one of the hypotheticals that I actually brought up. Judge Matthew Kaczmarek in Texas, when there was a challenge to the FDA's approval of mifepristone, briefly blocked access to mifepristone nationwide, saying the FDA never should have approved it in the first place, like all of it, not just the iterations that made it more accessible. He stayed that order, so it didn't ultimately take effect, but this is for the purpose of answering a question about abortion. But he issued that nationwide injunction, and that would have blocked access to mifepristone, which is the most commonly used, which is used in medication abortions, which is the most common method of abortion in the United States. So that's an example of how the other side used it to their benefit. They filed the case specifically where they knew Kaczmarek would get it and benefited from a universal injunction. So, was that V who was asking that question? I didn't see it. Does that answer your question, to deny abortion national rulings? It's going to apply to every ruling. I hope that's answering the question, but if you want to re-ask it, I will try. Chan can also text me, because there are a lot of questions in the chat. Let me see where we are. Sotomayor is still reading from her dissent. This means Sotomayor's, as David put it in the chat, is big mad. This is a long time for one decision, and she wants to take her time reading from the bench, because this is the only time that she will have to actually talk about the decision in this way. So she's still reading from her decision. Yeah, how does this apply to other cases is the question. We're going to have to read the decision more, but yeah, it basically gets rid of universal injunctions, but says that the judges need to ensure that their decisions apply to the plaintiffs before them. And there are just all kinds of different cases with different postures and different plaintiffs. Even in this one alone, there are organizational plaintiffs, there are individual plaintiffs, there are state plaintiffs. But yes, it does seem to get rid of the practice of nationwide injunction, because they're saying this is a core statutory constitutional issue, that this exceeds the authority that Congress has given the courts by issuing these nationwide injunctions. Sotomayor still reading. It is going to be a long morning. Yeah, I know. Coffee is a good idea. The court says at the end that the executive order won't go into effect for 30 days. So they're giving lots of people 30 days to challenge the executive order as applied to them, and for courts to potentially certify class actions or something. Do I know when the next decision comes out? It's going to come out in a few minutes. She's winding up. All right, so Amy's going back in now. So I'm going to go back to hitting refresh, because Sotomayor is wrapping up her dissent. Only one decision, guys, and we're 30 minutes in. Can I repeat the decision? Yes, Shay. So we just got the decision in the so-called birthright citizenship case. It's really about universal injunctions. And the Supreme Court said that it likely exceeds the authority that Congress granted the courts for a single district court judge to block the president from implementing his executive order, in this case on birthright citizenship nationwide. And they sent the case back down to the district court judges to ensure that their orders, let me read the exact language, they partially stayed the injunctions, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. And so the court's going to have to figure that out. Complete relief for each plaintiff with standing to sue. And this is about birthright citizenship. It doesn't take, they say at the end of the opinion, the birthright citizenship executive order won't take effect for 30 days, which means lawyers are going to be busy over the next 30 days filing requests in the courts. All 50 states won't sue. Somebody asked if all 50 states will sue. There are a number of states who are supportive of this interpretation of birthright citizenship. I'm hitting refresh now on the next decision. Yeah, 119 pages. What does it mean? It means a judge can't block something nationwide when you come to them with a problem. They can block it as applied to you as a plaintiff, and people similarly situated if you all file together as plaintiffs, like a group of pregnant women who are in the country illegally and are worried about the citizenship of their children. That would apply to all of the plaintiffs in that case. It does not eliminate birthright citizenship. The ultimate issue of birthright citizenship has not been addressed. This is just about whether Trump can try and implement it in places where a judge has not blocked it. And they've got 30 days. The lawyers have 30 days to try and get it blocked as broadly as they possibly can, I guess. You guys know I said this during oral argument, but I didn't hear, they weren't debating the merits of birthright citizenship, but I didn't hear a single justice suggest that the executive order was constitutional, and I heard a number of justices say, you know, it's not constitutional. So, but that will have to be a question for another day, because that's not what they're addressing. Woo! 30 minutes in and only one decision. We still have 5 more to go.
Oh, God.
If we go into Lion lunch hour, we won't break in, right? Will you ask them?
I don't know.
Okay.
Could be.
Well, I guess with the Montgomery County case, we will.
Yeah.
Okay.
I mean, I think they could break into a cooking of a casserole for this, right? No comment.
Okay, next one is Kennedy. No, I have it that way on purpose.
Oh, I see. I'm sorry.
Brett Kavanaugh writing the Kennedy v. Braidwood decision. The task force members are inferior officers whose appointment by the Secretary of HHS is consistent with the Appointments Clause. Even the Trump administration backed the task force here, so this is a win for the task force that selects what is covered by insurance providers. I'll get to the meat and potatoes of the decision. Hang on. It's Justice Kavanaugh joined by Roberts, Sotomayor, Kagan, Barrett, Jackson. Thomas filed a dissenting opinion joined by Alito and Gorsuch. Just briefly from the top, this case concerns the Appointments Clause of Article 2 of the Constitution. The U.S. Preventive Services Task Force, an entity within the Department of Health and Human Services, issues public recommendations about preventive health care services, for example, cancer and diabetes screenings. Before 2010, the task force's recommendations were purely advisory, but the Affordable Care Act of 2010 now mandates that health insurers cover some of the recommended services at no cost to the insured. The Secretary of Health and Human Services appointed the 16 current members of the task force. The question in this case is whether the appointment of task force members by the Secretary is consistent with the Appointments Clause in Article 2. That question turns on whether task force members are principal officers or inferior officers. Principal officers must be nominated by the President and confirmed by the Senate. Here's a quick summary here. Obamacare required insurance companies to cover preventive services, but it didn't specify what the preventive services were. And they created a task force with 16 volunteers who were supposed to be nonpartisan to select what is to be covered at no cost to the insured. The challengers here had a problem with the coverage and the approval of coverage for PrEP, which is an HIV prevention drug, among other things. And so they challenged the constitutionality of the structure of the task force, saying that they really had so much power that they are principal officers that should be appointed by the president and confirmed by the Senate. But here the Supreme Court is saying, in a decision delivered by Justice Brett Kavanaugh, it's 6-3 with Thomas, Alito, and Gorsuch in dissent, that they are inferior officers. And so the way that the Preventive Services Task Force right now is fine, is acceptable, and that they will continue to be able to work the way that they have, including approving things like PrEP to be covered by insurance companies. So that's a win for the people who defended the task force, including the Trump administration. I'm just going down to the dissent. This one's 86 pages. To promote democratic accountability, this is Thomas, joined by Alito and Gorsuch, the Appointments Clause establishes a default rule that all executive branch officers must be appointed by the president with Senate's approval. Congress may depart from this default by authorizing a department head to appoint inferior officers, but only if it does so expressly. This case concerns the U.S. Preventive Services Task Force, a body that issues legally, blah, 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 blah. Everyone now agrees that this practice was At the beginning of this suit, a subordinate official within the Department of Health and Human Services had for years appointed the task force's members. Everyone now agrees that this practice was unlawful. Everyone further agrees that no one statute provides for a department head to appoint the task force's members. But rather than accept the default mode of appointment applies, the government invented a new theory on appeal, arguing that the combination of two ambiguously worded statutes enacted decades apart establishes the Secretary of HHS can appoint the task force's members. Today, the court rushes to embrace this theory. I cannot. To begin with, I would not rule on the government's new theory before any lower court has done so. But if we are to decide this question now, I do not see how Congress has spoken with clarity needed to depart from the default rule established by the Appointments Clause. In ruling otherwise, this court treats the default rule as an inconvenient obstacle to be overcome, not a constitutional principle to be honored, and it distorts Congress's design for the task force, changing it from an independent body that reports directly to the president to one subject to the control of the Secretary of HHS. All right, so two decisions so far. First, in the Birthright Citizenship case, the court granted the Trump administration's request about universal injunctions and said it likely exceeds a district court judge's authority to grant a universal injunction, and that the courts should ensure that their decision applies essentially to the plaintiffs before them. But birthright citizenship and the implementation of the executive order is not going to happen for 30 days. The second decision is about the Preventive Services Task Force in HHS. Hang on, let me just make sure we're not going to another decision yet. Okay. The Affordable Care Act, Obamacare, requires insurance companies to provide coverage for preventive services. Preventive services, it doesn't list what those are, and so somehow HHS had to come up with what exactly that meant. They created a task force of 16 individual volunteers who are nonpartisan, who decide what's covered or required to be covered by insurance companies. You can't hear me? Somebody said they can't hear me. Can you hear me? Audio off. I don't know why the audio is off. Okay. Two people are saying they can't hear, but everyone else is saying they can't hear. And so this task force created the list of the things covered, including PrEP. A group here that had a problem with PrEP being covered challenged it and said that the task force's existence violates the Constitution because they should have to be appointed by the president and confirmed by the Senate to have this type of authority. The Supreme Court said no. The way that it works now, where they are appointed by a department head, agency head, is fine. So it's all copacetic for how they go through it. So this preserves the work of the task force and how they decide what is covered by insurance companies. Thank you, Shan. All right, 2 decisions down. They're still reading from it. I'm going to have coffee. Justice Kavanaugh wrote the decision, yes, PrEP, cancer screenings, all of those things are safe. Trump did defend the PrEP coverage. The administration, not directly, but the administration defended the task force. Nothing about RIFs yet. That's on the emergency docket, which we probably aren't getting right now. We might later. Okay, next one. Waiting for the next opinion. They're done reading from that one, so we should be getting the next one soon, I think. I'm going to hit refresh. So which one do we think Roberts has? Maybe he has gerrymandering, redistricting, Louisiana. So many people saying they can't hear me. Shan just had a pinned comment, which is go out and come back in, because everyone else is saying they can hear me. Okay, FCC v. Consumers Research. This is about the program, the E-rate program that provides access to internet and telephone access in low-income areas. The decision is delivered by Kagan, joined by Roberts, Sotomayor, Kavanaugh, Barrett, and Jackson. Kavanaugh and Jackson concurred. Gorsuch dissented, joined by Thomas and Alito. Several dissents by Gorsuch, Thomas, and Alito. The holding, the Universal Service Contribution Scheme does not violate the non-delegation doctrine. So, this case is about the E-rate program that subsidizes telephone and high-speed internet in low-income and rural areas, schools, libraries, communities, urban areas. Money from the subsidies comes from the Universal Services Fund. It's now actually raining. Created by Congress and funded through contributions from telecommunications carriers. A private nonprofit created by the FCC, known as the Universal Service Administrative Company, administers the fund. And a consumer protection group that goes after woke corporations challenged the whole scheme, saying it violated the non-delegation doctrine, which means Congress can't delegate its legislative powers to other entities. But here the Supreme Court is saying, no, it's cool. The Universal Service Contribution Scheme does not violate the non-delegation doctrine, which preserves the subsidies for high-speed internet access and telephone access in schools and libraries, etc., in low-income areas. From Kagan's opinion off the top. Nearly a century ago, Congress charged the then new Federal Communications Commission with making communication services available at affordable prices to all Americans. That objective became known as universal service. Some decades on, near the turn of the 21st century, Congress reaffirmed its commitment to universal service while providing new and more detailed instructions to the FCC about how to achieve it. Under the amended statutory plan, the FCC would use required payments called contributions from telecommunications companies to subsidize basic communication services for consumers in certain underserved communities, particularly rural and low-income areas. To carry out that mandate, the Commission established discrete subsidy programs for the consumers Congress had identified, set up a special fund to receive and disperse the company's payments, and enlisted a private corporation called the Universal Service Administrative Company to help manage that fund's operations. The question in this case is whether the Universal Service Scheme, more particularly its contribution mechanism, violates the Constitution's non-delegation doctrine, either because Congress has given away its power to the FCC or because the FCC has given away its power to a private company. We hold that no impermissible transfer of authority has occurred. Under our non-delegation precedents, Congress sufficiently guided and constrained the discretion that it lodged with the FCC to implement the Universal Service Contribution Scheme. And the FCC, in its turn, has retained all decision-making authority within that sphere, relying on the administrative company only for non-binding advice. Nothing in those arrangements, either separately or together, violates the Constitution. There is a 38-page dissent here. Why is it not going? Okay, let's look at the dissent briefly. Again, for those who are just joining, 3 decisions so far from the Supreme Court. They sided with the Trump administration in the universal injunction case, basically getting rid of universal injunctions, but it's kind of limited. They send it back down. They do get rid of universal injunctions. Second, they uphold the task force that decides what insurance companies have to cover under Obamacare, what preventive services, including PrEP. And third, they uphold the universal service scheme under the FCC that provides subsidies for internet and telephone service in low-income areas. That's 3 out of 6. I'm just going to read briefly from the dissent in the FCC case about the E-rate program, universal service. Kavanaugh concurred. Jackson concurred. Here's the dissent. Within the federal government, Congress alone has access to the pockets of the people, citing Federalist number 48, which is Madison. The Constitution affords only our elected representatives the power to decide which taxes the government can collect and at what rates. Throughout the nation's history, Congress has almost invariably respected this assignment. As this court observed some decades ago, it would represent a sharp break with our traditions for Congress to abdicate its responsibilities and bestow on a federal agency the taxing power. Today, the court departs from these time-honored rules. When it comes to universal service taxes, the court concludes an executive agency may decide for itself what rates to apply and how much to collect. In upholding that arrangement, the court defies the Constitution's command that Congress may not transfer to another branch powers which are strictly and exclusively legislative, otherwise known as the non-delegation doctrine. Zach is saying in the chat the court has not recognized a violation of the non-delegation doctrine since 1935. Fun fact. All right. Oh, man. 45 minutes in and we're only halfway there. 3 more decisions, including Mahmoud v. Taylor, which is the case about LGBTQ-themed books, gerrymandering and redistricting, and the Paxton case about age verification for adult content websites. Somebody said they get PTSD when they see me. Sorry. You're probably done with me for a while. Actually, while I have all of you, should we do lives when it's not opinions, like talking about oral arguments, talking about emergency docket decisions, talking about other stuff? Let me know if we should do lives other than people are saying yes. Okay. All right. I'll do it. Sure. Sure is meh. But I see lots of yeses. Yeah, they're just in the chat. They're talking about Gorsuch's dissent, which I just read to you. They're inside the court. Yeah, they're sitting for the argument. I mean, not argument, the decisions. Okay, cool. We'll definitely do it. I will do more lives. Recap. Sure. We're only halfway through. We have 3 of the 6 decisions that we're getting today. The first one was in the Birthright Citizenship case, which is really about universal injunctions. And there the court said that it likely exceeds a single district court judge's authority, basically to block the president from implementing his executive order nationwide. And so they granted the Trump administration's request to limit the 3 district judges' orders in this case that were blocking his definition of his interpretation of birthright citizenship nationwide to apply, and they're supposed to ensure that it applies to the named and relevant plaintiffs in the case. Okay, Amy's going back in to wait for the next one. So that was the first decision. The second decision was about the Preventive Services Task Force under Obamacare, which decides what preventive services, like cancer screenings and PrEP, that the insurance companies are required to cover at no additional cost to the insured. And the Supreme Court upheld the structure of the task force that currently does all of that work now. There was a challenge to the constitutionality of the structure of that task force, but the Supreme Court said, nah, it's cool. They're inferior officers that can be appointed. They don't have to be appointed by the president and confirmed by the Senate. And then in the third decision, the Supreme Court held up the constitutional scheme of the Universal Service Fund that the FCC uses to provide Mahmoud v. Taylor. Here we go. Justice Alito. This is the one about, I'm probably going to have to do a TV hit on this one shortly, so hang tight. We kind of think we know where this one is going. The holding. Parents challenging the board's introduction to the LGBTQ inclusive storybooks, along with its decision to withhold opt-outs, are entitled to a preliminary injunction. To both things. I think that is beyond just the no opt-out policy. So, Justice Alito delivered the opinion of the court, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Thomas filed an opinion concurring. Sotomayor dissented, joined by Kagan and Jackson. Okay, guys, I'm going to need a second to read the opinion, so give me a second. I'm going to need a second to read the opinion. The Board of Education of Montgomery County has introduced a variety of LGBTQ inclusive storybooks. They're saying that it violated the Constitution for the no opt-out policy. These books and associated educational instructions provided to teachers are designed to disrupt children's thinking about sexuality and gender. The board has told parents that it will not give them notice when the books are going to be used and that their children's attendance during these periods is mandatory. A group of parents from diverse religious backgrounds sued to enjoin the parents. They assert that the new curriculum combined... Okay. Today we hold that the parents have shown that they're entitled to a preliminary injunction. A government burdens the religious exercise of parents when it requires them to submit their children to instruction that poses a very... Yes, I can hear you. That poses a very real threat of undermining the religious beliefs and... Yes, I can hear you. I'm talking. My mic is on. Okay. Poses a very real threat to undermining the religious beliefs and practices that the parents wish to instill. Let me go down to the dissent. Wow, this one's even longer than this one's 135 pages. They include pictures. They include the pictures of the books. Let me go briefly to the dissent. Public schools, this court has said, are at once the symbol of our democracy and the most pervasive means of promoting our common destiny. They offer children of all faiths and backgrounds in education an opportunity to practice living in a multicultural society. That experience is critical to our nation's civic vitality. This is from the dissent, yet it will become a mere memory if children must be insulted and insulated from exposure to ideas and concepts that may conflict with the parents' religious beliefs. Today's ruling ushers in that new reality. Casting aside the longstanding precedent, the court invents a constitutional right to avoid exposure to subtle themes and contrary to the religious principles the parents wish to instill in their children. Okay, exposing the students to the message. I'm going to have to do a TV hit on this, so hang tight. Okay. Okay. Hey, good morning to you guys. Perhaps not unexpectedly, after the Supreme Court's oral argument, we kind of expected this ultimate resolution. But the Supreme Court here held that parents in Montgomery County who are from religiously diverse backgrounds, Muslim, Catholic, Orthodox, are likely to succeed on their claim that MCPS's no opt-out policy for their elementary school children to receive instruction involving LGBTQ-themed books likely violates their religious freedom. The parents, again of different religious backgrounds, had argued that the no opt-out policy impinged on their ability to teach their children about gender and sexuality in accordance with their religious beliefs, and not allowing them to opt out of that instruction, particularly for their elementary school children, violated their First Amendment right to freely exercise their religion. The Supreme Court today, in an opinion that was delivered by Justice Samuel Alito, it was 6-3 along ideological lines, the Supreme Court said that they're likely to succeed in that argument that the no opt-out policy violates their religious freedom. And Alito writes briefly in the opinion, "We've long recognized the rights of parents to direct the religious upbringing of their children, and we have held that those rights are violated by government policies that substantially interferes with the religious development of children." Now, again, I said this decision was 6-3. The court's liberal justices, led by Justice Sotomayor, dissent in this case. And Justice Sotomayor says that the reverberations of the court's error will be felt for generations. Unable to condone this grave misjudgment, she dissents, omitting the typically included respectfully dissents there. And what Justice Sotomayor is saying is that children, for a long time, public schools have been responsible for educating the nation's children, and that they offer children of all faith and backgrounds education, and that experience is critical to the nation's civic vitality, including exposing children to religious differences and people who believe differently. But of course, they are in the minority today. It was a 6-3 decision upholding the likelihood of success for the parents here in this case who are arguing that the no opt-out policy would violate their religious freedom. Now, what comes next? It goes back down and it'll get sorted through the courts. The ultimate decision, what happened here today is the Supreme Court just said that they were likely to succeed on their argument that this violates their religious freedom. One of the questions that came up during oral argument, one was about the age of these individuals. The Chief Justice mentioned during oral argument, even if the children aren't required to affirm what they're being instructed, that might be a difficult concept for an elementary schooler to understand. So age will be a part of the analysis going forward. But another question that came up from the liberal justices is, what's the limiting principle? What if parents don't want their children to be in the classroom with a teacher who is gay or with a student who is transgender? So that is also going to have to be sorted out. But for now, the Supreme Court is siding with the group of Montgomery County parents from religiously different backgrounds who are arguing that MCPS's no opt-out policy violates their free exercise of religion and ability to instruct their children the way that they wish about gender and sexuality in accordance with their religious beliefs. So a loss for MCPS today at the Supreme Court. All right, thanks. I don't know if we've gotten the next decision yet. Hang tight. No, we haven't. Okay, cool. Thank you.
Find out what that noise was on our IFB.
Yeah, somebody talking. I'm going to take my IFB out. I don't think they need me anymore. Plus, we're about to be in line lunch hour. Okay. At the end, the court says, while this case moves forward in the lower courts until all appellate review in this case is completed, the board should be ordered to notify them in advance whenever one of the books in question or any other similar book is to be used in any way, and to allow them to have their children excused from the instruction. So it's both a notification component. They need to notify parents when these types of books are used in instruction, and they need to allow the parents to opt out of that instruction. That's what the Supreme Court says, again, at the end of their majority decision today. It was 6-3. Along ideological lines, a loss for Montgomery County Schools, a win for the parents, again, who had religiously different backgrounds. It was a group of parents who were Muslim, Catholic, and Orthodox, all arguing that this no opt-out policy violated their right to freely exercise their religion and their ability to instruct their children in accordance with that religion on things like gender and sexuality. Sotomayor's dissent starts by quoting from a 1987 opinion describing public schools as at once the symbol of our democracy and the most pervasive means of promoting our common destiny. Whew. At least I'm done with the TV hits for now.
Never say never.
I know, never say never, but I think I'm done with the TV hits for now. Oh, I'm okay, thank you. I ate right before. I carved up for opinion days.
No.
not really, but Starbucks, ham and cheese croissant, that's carbs. The coffee order is iced black coffee. All right. Can I summarize the opinions? Sure. I'm just looking at the chat. All right, so 4 decisions so far. We still have 2 more, including age verification for adult content and the redistricting case. Amy seems to agree with me in the chat that maybe the chief is the one who has the Louisiana redistricting case. All right, so the first decision was in the Birthright Citizenship Universal Injunctions case, where the Supreme Court basically got rid of universal injunctions, saying that that likely exceeds a district court judge's authority granted by Congress, and said that they were granting the Trump administration's request to limit the injunctions in the birthright citizenship cases to the plaintiffs, basically before them in each case. There are 3 separate cases, one out of Massachusetts, one out of Maryland, and one out of Washington, where 3 separate judges, just make sure we're not getting a new one, where 3 separate judges blocked the president from implementing his executive order on birthright citizenship nationwide. And so we have 30 days until the birthright citizenship order will take effect, and now lawyers will go to work arguing basically to get as broad of an application as possible to blocking the order from taking effect. In the second decision, the Supreme Court upheld the constitutional structure of the Preventive Services Task Force, which is the task force in HHS that decides what preventive services are required to be covered by insurance companies under Obamacare at no cost to the insured, including things like cancer screening and in particular PrEP. A group had challenged the coverage of PrEP, arguing that the Preventive Services Task Force was unconstitutional because they were really important principal officers, as it's called in the Constitution, but they were so important to the structure of what's happening at HHS that they need to be appointed by the president and confirmed by the Senate, but the Supreme Court said no. How it works now is fine, and upheld the structure of the Preventive Services Task Force. So everything that has been ordered by them for now, all of that preventive stuff like cancer screenings and PrEP, all covered, all good for now. In the third case, the Supreme Court upheld the Universal Service Fund scheme, which is how the FCC provides subsidies to low-income urban areas for high-speed internet and telephone services. Again, there was a constitutional challenge to that, arguing that, well, that it violated the non-delegation doctrine, that Congress was giving its authority away and it wasn't supposed to, or that the FCC was giving its authority away that Congress had given it. And the Supreme Court said no, the way that it works now is fine. So that preserves the structure for access to those E-rate subsidies. And then just now in Mahmoud v. Taylor, the Supreme Court said that a group of parents from religiously diverse backgrounds were likely to succeed on their challenge of Montgomery County Schools' no opt-out policy. They were not allowed to opt their elementary school children out of instruction involving LGBTQ-themed books. The parents had argued that violated their right to freely exercise their religion, and the Supreme Court said that they were likely to succeed in that argument, sending it back down to the courts. That is your summary of the 4 we've gotten so far. The 2 that are remaining: age verification for adult content websites, which is probably Thomas, and Louisiana's redistricting case, which is a complicated one. No RIF update yet. We could hear about RIF today. It's possible. 2 more. Sotomayor is still reading from her Dissent, which means coffee time. Whoever just said I'm late, I will give you another rundown in a second. I just did an in-depth rundown of the 4 we've gotten so far. Yes, birthright already happened. The Supreme Court sided with the Trump administration not on the substance of birthright, but on universal injunctions. We don't have the redistricting decision yet, but the case is about Louisiana's map. The first one was drawn after the 2020 census. Louisiana has a third of its population is black, but the map they drew for their 6 congressional seats included only one majority black district. That got challenged as violating the Voting Rights Act. They redrew a second map through a complicated process that had 2 majority black districts. Then a group of non-black individuals said that violated the Voting Rights Act because they redrew the lines based on race. And that went up to the Supreme Court. And Louisiana's defense of it is that we didn't redraw based on race, we redrew based on politics. Is the Mahmoud ruling now limited to the filing parties because of CASA opinion? Yes. Oh, interesting. No, it applies. Well, that's a good question. I think it applies to MCPS through the parties, right? It applies to MCPS. It's on MCPS. The MCPS now has to notify and allow an opt-out. But that's a good question. Yeah, because the parties are the board and MCPS. All right. People asking me my opinion in the RIF case, so it has not come out yet. That's an emergency docket decision. We're doing merits this morning, although we might get RIF later. I think that the court is likely to allow the Trump administration to do as they wish when it comes to employment in the executive branch. But we'll see. We have 4 out of 6. We have 2 more that we're waiting on. I will do another summary when the next one comes down. It sounds like, is it Sotomayor or Kagan? Sotomayor. I think it's Sotomayor still reading. Okay, Amy says it sounds like Sotomayor is wrapping up, so she's going back in. So we go back to hitting refresh on the court's website. Only 2 left. The 2 cases left are Paxton, which is about age verification to adult content websites, really about the test that applies when examining whether those laws are constitutional, strict scrutiny, or a rational basis. That's the one I think we'll be getting next. And then the Louisiana redistricting case that I was just explaining to you guys. Thomas, we're guessing. I don't know yet. It's not out yet. But Thomas on Paxton is what we think is next. Which it could only be Thomas or the chief because Alito just did his decision. We might have to upgrade the chair for this day next year. I'm just hitting refresh, waiting for the next decision. Ah, interesting. People talking about whether there will be a retirement announcement after today. I don't think so, but possible. possible. Now it's really raining. Refresh, 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 refresh. In the rain. Dang it. I'm going to do this lower.
Wet?
Yeah. No, I'm good.
You good?
Yeah. Yes, I'll explain birthright citizenship again in a second. We're about to get the next one.
It's 30 degrees cooler today. Yeah. Yeah, I'm with you on that. Yeah.
Waiting, waiting, waiting.
Yeah. Yeah, she's got us down. Yep, yep.
Still waiting. Four out of 6. We've got 2 more. Next one is probably Paxton. For First Amendment nerds, it will be quite interesting. For adult content nerds, it will also be quite interesting. Anybody want to place bets on whether we get a retirement today? Yeah, the question is whether it's content-based or content neutral. The question is what test applies for whoever was just asking. In the First Amendment world, if a law is content-based, meaning about the content of the speech itself, then it's you examine it using strict scrutiny, which requires the government to say, this is our compelling government interest, and this is how the law is very narrowly tailored to that compelling government interest. But if it's content neutral, rational basis applies, which just requires the government to have a legitimate interest and the law to be rationally related to that interest. So the question in this Paxton case that's coming up, which we haven't gotten yet, is going to be which test applies. And it is possible, even if strict scrutiny applies, that the law passes muster. I believe the way the law works is that it requires the age verification if more than 30% of the content more than 30% of the website would be harmful to children. How come cameras aren't allowed in Supreme Court hearings? Great question, because the Supreme Court can do as they want. They don't want cameras. We were talking about this a little bit earlier. Part of the concern on the justices is that it will become like performative and theatrical, like Congress giving speeches on the floor. If there's a camera there, people will perform for the cameras instead of focusing on the justices' questions. And even the justices themselves may be tempted to engage with the cameras and the American public. And another argument is about safety. Because people don't see the justices every day. They can't identify them on the streets. And in a world where there are increasing threats not only against public officials, but particularly against judges, perhaps that would make sense. But I believe in cameras in the courtroom. That I'm an advocate for that, so I have a bias there. Nothing yet. I don't know why this one's taking so long. Oh, we have Free Speech Coalition. V. Paxton. From Thomas. I just got an R number. They're not going to deal with Louisiana redistricting? I don't know. That's weird. Okay, the holding is HB 1181 triggers and survives review under intermediate scrutiny because it only incidentally burdens the protected speech. So they went ahead and reached the merits too. They didn't just say what test applies. And it's intermediate scrutiny, and they say it passes. Thomas delivered the opinion of the court, joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. Kagan filed a dissenting opinion, joined by Sotomayor and Jackson. 6-3, along ideological lines. Texas, this is about age verification for access to adult content websites. The Supreme Court says it is subject to intermediate scrutiny, and it survives intermediate scrutiny. So these laws will be permitted. Texas, like many states, prohibits the distribution of sexually explicit content to children, but although that prohibition may be effective against brick and mortar stores, it has proved challenging to enforce against online content. In an effort to address this problem, Texas enacted the law in this case, which requires certain commercial websites that publish sexually explicit content to verify the ages of their visitors. This requirement furthers the lawful end of preventing children from accessing sexually explicit content, but it also burdens adult visitors of these websites who all agree have a First Amendment right to access at least some of the content that the websites publish. We granted cert to decide whether these burdens likely render it unconstitutional under free speech and the First Amendment. We hold that they do not. The power to require age verification is within a state's authority to prevent children from accessing sexually explicit content. It's constitutionally permissible exercise of that authority. Let's briefly go to what the dissent says. Opinion of the court. Kagan, joined by Sotomayor and Jackson. No one doubts that the distribution of sexually explicit speech or to children of the sort involved here can cause great harm. Or, to say the same thing in legal terms, no one doubts that states have a compelling interest in shielding children from speech of that kind. What is more, children have no constitutional right to view it. The Texas statute before us addresses speech understood in First Amendment law as obscene for minors. That label means the First Amendment does not protect the speech for minors. The state can restrict their access without fear of colliding with the Constitution. The trouble comes in the last two sentences, italics. Speech, which you can't see, but speech that is obscene for minors is often not so for adults. For them, the category of obscene and therefore unprotected speech is narrower. So adults have a constitutional right to view the very same speech that a state may prohibit for children. And it is a fact of life and also of law that adults and children do not live in hermetically sealed boxes. What a great sentence. I'm going to reread it. And it is a fact of life and also of law that adults and children do not live in hermetically sealed boxes. In preventing children from gaining access to obscene for children speech, states sometimes take measures impeding adults from viewing it too, even though for adults it is constitutionally protected expression. What then to do? Cases raising that question have reached this court on no fewer than 4 prior occasions, and we have given the same answer consistent with general free speech principles each and every time. Under those principles, we apply strict scrutiny, a highly rigorous but not fatal form of constitutional review to laws regulating speech protected based on its content. And laws like HB 1181 fit that description. They impede adults from viewing a class of speech protected for them and defined by its content. So when we have confronted those laws before, we have always asked the strict scrutiny question: is the law least restrictive means of achieving a compelling state interest? There's no reason to change course. I don't know what's happening with Louisiana redistricting because I got an R number. Did we get that? It's going to be re-argued next term. Okie dokie. All right. those are all 5 decisions. The Louisiana redistricting case is going to be re-argued next term. And it looks like Thomas dissented from the decision to have it re-argued. All right. So I'm going to give a summary. We've been on for almost 2 hours. So this is going to be your last summary, and I will post a video of the summary. So everybody get ready, because here comes your one and only summary. Is everyone ready? Okay. We got 5 decisions from the court today instead of the expected 6 because the Louisiana redistricting case, they moved to next term and it is going to be re-argued. Justice Thomas dissented from that decision. In the first decision of the day, Justice Amy Coney Barrett, writing for the court's majority in the Birthright Citizenship / Universal Injunction case, where the court said that it likely exceeds a district court judge's authority to issue a universal injunction, which had been used by 3 separate district court judges to block the president from implementing his executive order on birthright citizenship nationwide. Judges out of Maryland, Massachusetts, and Washington had blocked President Trump from implementing that nationwide. The Supreme Court said that likely exceeds the judge's authority, sent it back down and said the judge needs to ensure that the decision applies to the plaintiffs before him or her. There are multiple plaintiffs in these cases, individual pregnant women who are here in the country illegally who are going to give birth, states, and organizational plaintiffs. The Supreme Court granted the Trump administration's request to narrow those injunctions as applied to the people before them. That's the first decision of the day. In the second decision of the day, the Supreme Court upheld the Preventive Services Task Force. Obamacare requires insurance companies to cover preventive services, things like cancer screenings, things like PrEP, an HIV prevention drug. And a group they didn't say what preventive services had to be covered, so HHS created a task force with 16 people who are nonpartisan to decide what insurance companies are required to cover, not on the burden of the insured. A group challenging the fact that they selected PrEP to be covered, among other things, and also the constitutional structure of these individuals, lost. The Supreme Court upheld the Preventive Services Task Force. They had argued that individuals with that kind of power needed to be appointed by the president and confirmed by the Senate, that they were principal officers. But the Supreme Court said no, they are inferior officers and they can exist as is. So all of the preventive services that have been selected as required to be covered by insurance companies all still stands. And the third decision involving the FCC's E-rate program that provides subsidies for internet income, for high-speed internet and telecommunications phone systems in low-income areas. The Supreme Court upheld that program, even though it had been challenged as Congress violating the non-delegation doctrine, basically Congress giving away authority that it couldn't give away, or the FCC giving away authority that it couldn't give away. So the E-rate program survives, the Universal Services Fund scheme survives. In the fourth decision, in Mahmoud v. Taylor, the Supreme Court said that parents from religiously diverse backgrounds who were suing a school system, Montgomery County Schools, who were blocking them from opting out their children from instruction involving LGBTQ-themed books, elementary school children, the Supreme Court said that those parents were likely to succeed on the merits of their argument that no opt-out policy violated their right to freely exercise their religion under the First Amendment. And then finally, the Supreme Court said in the Texas case about age verification for access to adult content websites, that Texas's law requiring age verification for the ability to access adult content websites is subject to intermediate scrutiny because it does incidentally touch on speech, but it is not content-based, according to the court's majority, and it survives intermediate scrutiny. So laws similar to the one on the books in Texas that require age verification for access to adult content survive constitutional scrutiny and can continue to exist. There are a number of laws like that on the books across the country, so those are all safe. Again, the Louisiana redistricting case going to be argued next term. A lot of you have been asking about the reduction in force decision. That's on the emergency docket. We could get that this afternoon. We could get that Monday. We don't know for sure. We don't get the timing on that one. And that is your summary. I'll post a TikTok of the summary also of the cases. Sure. Next term starts in October. The justices have left the bench. I'm going to leave the TikTok bench. Thank you all for joining us. 'Twas fun. we'll keep doing lives over the summer. We won't just limit them to opinion days now that you guys have decided that we can do more lives. Have a lovely weekend, everyone. Have a lovely July 4th. Thank you all. Thank you, thank you, thank you. I will come back for the emergency docket, I promise. Thanks, guys. Wow, you re-downloaded TikTok for this. That is commitment. The emergency docket is we have no idea when. We just get that decision. It might be this afternoon. All right. I'm going to go do my other day job. Bye, guys.
Thanks a lot. See you the first Monday.
Yeah. See you first Monday. Thank you. I'll do a TikTok right now summarizing all the decisions. You guys have it in your back pocket. Bye. Okay. Oops. Oh, that's getting wet.
You did. Your phone got wet over there. Or no,
Oopsies. Oopsies.
What's the deal? Are you going to be able to get out of here? Or?
Oh, no. I'm reporting for the day. We're doing
you
this
are?
today. Yeah.
Oh, so this is us for the day.
Yeah. Sorry if you
No, that's okay.
thought you were escaping.
I did. They weren't sure. I mean, or I was, so, all right, that's good to know.
I think we're going to be look lives after the 4 o'clock, though, because we started so early.
After the 4, I see.
Yeah.
Am I going to need any B-roll or?
Yeah. But we have B-roll from the Montgomery County cases of protests happening out at the school. The 2 the 3 I'm going to cover are the age verification case, which we have done.
All right, so.
I don't know why I
What the
just
slug would be for the most.
for MoCo.
Yeah.
It's going to be a lot of. We've covered it a million times, like all the way up and down the courts. There's just going to be a bunch of stuff.
So MoCo something or other.
No opt-out policy, LGBTQ books.
Okay. Yeah.
And
then what else?
The age verification, so adult content websites. We have some blurred out video of adult content with porn websites. And then birthright citizenship. And we can also use some generic Supreme Court video. Woo! Hi, how did it go, guys? Was it intense?
Yeah.
Why
They
so
were all
intense?
staring each other
Yeah,
down.
they're like Kagan side eyes me.
and
And so was Jackson. She was like,
Clarence
wasn't there.
he wasn't there, yeah. And Clarence Thomas kept like leaning back.
Oh,
in
he
his
always
seat.
does that, yeah.
It was really
He's
strange.
straight up chill.
Really strange.
Yeah.
We were all like, what's going on?
Yeah. Cool. I'm going to do a quick summary on TikTok, and then what are you guys doing? You're going back to the station, I assume.
I don't think I am.
You're not.
Are you?
Or neither of you are working today.
Yeah,
I'm
no, I
supposed
wasn't
to
working
today.
Oh,
but-
then go home. I'm just going to be doing this. Yeah. Same old, same old. But I'm glad you guys got to go.
Yeah, it was really intense.
It was crazy.
Well, you got to see some history.
my mom was like, "What's happening about one?" I was like, "I like one."
You're welcome. You're welcome. I'm glad you got to enjoy it. Okay. Preventive Services, FCC, Montgomery Big Taylor, Paxton case. Hi guys, I'm just off the live. I'm going to do a quick summary of the 5 decisions we got from the Supreme Court today. It was the last day of decisions. We got all of the major ones we've been waiting on, plus a surprise at the end. The Louisiana redistricting case is going to be pushed and re-argued next term. But starting with the first decision, and perhaps the biggest we got today, was Trump v. Casa, the so-called Birthright Citizenship case about universal injunctions. In that case, the Supreme Court granted the Trump administration's request to narrow universal injunctions that had applied nationwide to the individual plaintiffs for each party. 3 different district court judges had blocked the Trump administration from implementing his executive order on birthright citizenship nationwide, and the Supreme Court said that universal injunctions, nationwide injunctions, likely exceed the authority of an individual district court judge, the authority granted to the courts by Congress. And in doing so, they granted the Trump administration's request to narrow those injunctions. The executive order is not going to take effect for 30 days, and the court said specifically that they're not deciding whether the executive order is constitutional, whether birthright citizenship, the definition in Trump's executive order, is constitutional. They instructed the district courts to move expeditiously to ensure that with respect to each plaintiff, and there were different types of plaintiffs in these cases. There were individual pregnant women who were giving birth soon, who were in the country illegally. There were organizational plaintiffs, and there were state plaintiffs. But with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with the principles of equity. In the next, that was delivered by Justice Amy Coney Barrett. In the next decision, the Supreme Court upheld the Preventive Services Task Force. And this comes out of Obamacare, which requires insurance companies to cover preventive services, but doesn't specify exactly what preventive services have to be covered. And so HHS has a Preventive Services Task Force with 16 volunteers who are nonpartisan, independent, and decide what insurance companies are required to cover. And that includes what the preventive services like cancer screenings, PrEP, the HIV prevention drug, and challengers had argued against the coverage of PrEP, but also argued that the structure of the task force was unconstitutional and that people basically with that much power need to be appointed by the president and confirmed by the Senate. But the Supreme Court said no, they are inferior officers and the task force can continue to exist. Recall, the task force was defended even by the Trump administration here. So all of those preventive services still covered, are required to be covered by insurance providers. In the third case, the Supreme Court upheld the E-rate services program, the program, a universal service fund program that provides subsidies for high-speed internet and telephone access in low-income areas across the country. Again, that was challenged as violating the non-delegation doctrine, as Congress giving away too much of its power, or the FCC giving away too much of its power that Congress had given it. But the Supreme Court said that program is fine, the way that works is fine, and the universal service scheme survives. In the fourth decision, Mahmoud v. Taylor, the Supreme Court said that parents from religiously diverse backgrounds who were arguing against a local school board's policy that prevented them from opting out their elementary school children from instruction involving LGBTQ-themed books. The Supreme Court said those parents who were challenging that no opt-out policy were likely to succeed on their argument that violated their right to freely exercise their religion and instruct their children on things like gender and sexuality in accordance with their own religious practices. So now the school board has to not only notify the parents when those types of books are being used in elementary school instruction, but also give them the option to opt out. And finally, in the last decision of the day, the Supreme Court in the Paxton case about Texas's law that requires age verification in order to access adult content websites, in a decision delivered by Justice Thomas, the Supreme Court said that law is subject to intermediate scrutiny because it incidentally affects speech and the content of speech, but that it survives intermediate scrutiny. So states can require age verification for access to adult content websites. Again, 5 decisions today. The Louisiana redistricting case will be argued next term. If you want me to delve into the specifics of any of the decisions, drop it in the comments, and I'll see you later. Hi, guys. Hi, guys. I'm just on the line with somebody.
Your daughter, like my daughter,
Access to adult content websites. Again, 5 decisions today. The Louisiana redistricting case will be argued next term. If you want me to delve into the specifics of any of the decisions, drop it in the comments, and I'll see you later.
yeah, I like it. You slow, you carry those, those, whatever those, we fit all our stuff on. Yellow way better, but anyway.
Okay, I thought Katie was thinking she's done. Wait, hold on.
What?
I mean, I got you on speaker, Kenny. Go ahead.
I don't think I'm done. We're recording today.
No, I meant like for right now.
Oh, yes. One other thing we have to do, though, is a 1:30 interview. We have to do a 1:30 interview, like, through the camera. Sorry, Kenny, what's up?
I just wanted Nelson said that he was breaking the shot down. I wanted him to keep the shot up. We're waiting on the president to speak. And, I just need you guys to be ready in case for any reason we do need to come to you guys.
Oh, fine.